Hello, Prophet Ron Dwayne Whitfield recording on January 8th, Tuesday, 2019. Prophet Ron Dwayne Whitfield recording January 8th, 2019.
Houston, Texas, 77021. January 4th, 2019. Happy 25 years on top of the ground, wife. Mr. Blake Hawthorne, clerk, Mr. Chief Justice, and Mr. and Mrs. Associate Justices of the Supreme Court of Texas. Supreme Court of Texas. 201 W14, Room 104. Austin, Texas, 78711. Law of Texas. Preamble. Presumed father versus alleged father. Family Code. Title 5. The parent-child relationship and a suit affecting the parent-child relationship. Chapter 101. Definitions. SEC 101. 001 Applicability of definitions. A. Definitions in this subchapter apply to this title. Sector 101. 0010 Acknowledged father. Acknowledged father means a man who has established a father-child relationship under Chapter 160. Sector 101. 0015 Alleged father. A. Alleged father means a man who alleges himself to be, or is alleged to be, the genetic father or a possible genetic father of a child, but whose paternity has not been determined. B. The term does not include 1. A presumed father, 2. A man whose parental rights have been terminated, or 3. A male donor. Family Code Title 5. The parent-child relationship and the suit affecting the parent-child relationship. Sections .160.102. Definitions in this chapter. 1. Adjudicated father means a man who has been adjudicated by a court to be the father of a child. 11. Parent means an individual who has established a parent-child relationship under Section 160. 201. 13. Presumed father means a man who, by operation of law under Section 160 204, is considered by Texas law as the father of a child until that status is rebutted or confirmed in a judicial proceeding. Subchapter C. Parent-child relationship. Sector 160.201. Establishment of parent equals child relationship. B. The father-child relationship is established between a man and a child by 1. An unrebutted presumption of the man's paternity of the child under Section 160.204. By authority of the Supreme Court of Texas decision in the interest of PM, a child, docket numbers 15-0171 and 11-0114 and 11-0222. In this case, the trial court judge rendered final judgment when it orally announced the divorce. A court's oral judgment is its announcement of the resolution of the issues in a lawsuit and is rendered when the judge of the trial court officially announces its decision either in open court or by written memorandum filed with the clerk. S. and arrest. Corp v. Leal, 892 SW2D 855, 875, Texas 1995, citing Comet Aluminum Co. v. Dibrell, 450 SW2D 56, 58, Tex. 1970, other citations omitted. A trial court through her trial judge renders judgment orally when it announces rendition as a present act and not as an intention to render judgment in the future. ID. At 858, quoting 534 SW2D 329, 330, Texas 1976. Its judgment is final as of that date, even if the judgment is void or otherwise flawed. Pro Se Motions of World's Last Prophet, Ronald Dwayne Whitfield, father, and of Brandy Brina Charles Whitfield, mother, together with their limited petition for review, with inclusive plea to the jurisdiction of the courts, over both their person, their child, and of the subject matter, which litigation was bootstrapped into controversy, and of the original motion of said prophet as presented below in original text to local administrative judge, Honorable Robert Schaefer of Harris County, Texas, seeking an order for his permission for said father to file in the District Courts of Harris County, Texas, proposed litigation, to challenge, as unconstitutional, laws of the state of Texas, and to appeal an oral rendition of a void future judgment announced from the bench in the room of the court by her presiding trial judge, Honorable and former Judge John F. Phillips, of the 314th Judicial District Court of Harris County, Texas, Trial Court Cause Number 2017-02559J, in the interest of KLW, a child, which he subsequently granted, and, finally, of the placing all 9 members of said court on legal and official notice that this last prophet is not any attempted adjudicated, alleged father, whose parental rights, if any, Judge Phillips judicially tried to terminate against, since Judge Phillips' attempt of rendition of oral judgment failed, because it must be pronounced as a present, not as a future, judicial act in order to be a valid rendition of judgment. See Supreme Court of Texas same-sex marriage decision in case numbers in the Supreme Court of Texas 11-0114 and 11-0222 to orally terminate, but that he is what Texas law describes as the presumed father, Texas Family Code Section 160. 204. A. 1. A. A man is legally presumed to be the father of a child if 1. He is married to the mother of the child and the child is born during the marriage, the legal father, and that father was neither sued nor served with a citation and copy of the state's petition to terminate anyone's rights to any child, thus whose God-given parental rights the statement of facts prove that the prosecutor and Judge Phillips went back and forth about at a court trial in which termination of parental rights was presented for resolution as between some alleged, as distinguished from, the presumed father, for while said prosecutor requested this judge to adjudicate and terminate rights of the presumed father, Judge Phillips rejected it, suggesting to the prosecutor to request that the frivolous rights of the alleged father be terminated instead. Again, said prosecutor introduced into evidence at the beginning of the court trial without jury the marriage license of the parents of the child to one another and requested Prophet Ronald Dwayne Whitfield by the judge be adjudicated as the presumed father, not the alleged father, and, as such, that the rights of the alleged father be terminated for failing to register himself as a possible father, and therefore for judge to terminate the parental rights of the presumed, not the alleged, father, and yet he refused to so do. He wanted to terminate instead the suspects, not the accused's, parental rights. This Maria Valeria Brock, attorney on appeal, and yet who argued in the hearing on motion for new trial that the court lacked personal jurisdiction because the presumed father was not sued and served, somehow now would have the world believe she has forgotten, and also, that even Judge Phillips himself made just such a finding that the father was not served, in an order dated as and filed on May 18, 2018, which also extended time to conclude a full adversary hearing. That motion reads and appears as and reads as follows. Re, in the interest of KLW, a child, trial court cause note 2017025559J, in the 314th Judicial District Court of Harris County, Texas. First Court of Appeals docket no 01-18-00485 CV. Pro Se petition for review, C. Marsh v. State, 959 S.W.2D 224. 1996, not on the merits, but following the instructions of a deputy clerk of the Supreme Court of Texas, that the presumed father needs to file in the Supreme Court of Texas his own pro se petition for review, in order to bring to the attention of the court that the First Court of Appeals of Texas has denied appellate counsel Marie Valeria Brock's motion to withdraw, after she first filed an Anders brief but on an incomplete record, in violation of Anders v. California, 386 U.S. 738, 1967, where all the proceedings must be examined to determine on whether or not an appeal would be, as counsel asserts, wholly frivolous, without merit, together with motions inclusive in the petition for review, such as for orders to the said attorney and to the court reporter to show legal cause as to why each one of them should not be held in legal contempt of court, and for an order that the court reporter either provide all the records of the proceedings or both parents be ordered a new trial. Re. A duplicate of the proposed litigation of Prophet Ronald Dwayne Whitfield that Harris County Local Administrative Judge Robert Schaefer granted to authorize the Prophet to appeal, ruling it arguably has merit, and yet a sham appellate attorney somehow has overruled the judge, asserting in an Anders brief that the appeal has no merit and is frivolous, an appeal attempted by the Prophet to be taken from the future, not any present, act, of an oral rendition of judgment, publicly announced by former Judge John F. Phillips of the 314th Judicial District Court of Harris County, Texas, on April 12, 2018, from the bench, specifically announcing, "I'll grant your request," which was to be but has not been, as well as further entered of record into the minutes of the trial court by the clerk of the trial court. Re. Letters and orders of Harris County Local Administrative Judge Robert Schaefer. Dear Mr. Clerk, Mr. Blake Hawthorne, Clerk of the Supreme Court of Texas. Dear Mr. Chief Justice and Mr. and Mrs. Associate Justices of the Supreme Court of Texas. As you know, this court recently ruled that indigent parents' right to appointed appellate counsel continues through appeal to the Supreme Court. The attorney has refused and has failed to file in this court a petition for review and a motion to withdraw. Discussion. Please. Refusing us of our real God-given right to select and hire our own counsel to advise and assist us in this matter. My wife and I were separately ordered by Judge John F. Phillips on May 18, 2017, appointed sham attorneys, for the sole purpose of securing for the deep state's kidnapping state of our then 8-month-old baby. The plan was to be completed by not allowing our side of what happened be told in court to a jury, and to appoint on appeal additional court-appointed appellate sham attorneys who were instructed to present Anders briefs asserting that the Court of Appeals lacked jurisdiction to hear any legal issues below because the appeal was frivolous, wholly without merit, and the justices of the First Court of Appeals was to agree, and we were to be total ignored on direct appeal, as we were in the trial court, to be finally deprived of everything our real God gave us in violation of substantive and procedural due process, the violation of the unlawful seizure and removal of our child by the deep state, through a component thereof, the Texas Department of Family and Protective Service, aka CPS. In fact, when our son was kidnapped by CPS for the deep state on Sunday morning, May 7, 2017, the deep state had previously barred me from filing any civil actions in the Texas courts unless I first somehow could convince a judge that such proposed litigation being tendered in advance of filing would have merit, and not be frivolous, and not brought in bad faith for purpose to harass a defendant. As such, kidnapping our child and denying me a right to do anything about would be easily accomplished, for after the final decree being filed, before I would be able to appeal from it, I had to obtain another judge's permission, which obviously the deep state presumed in no way would I obtain. But as we shall see and read and hear below, the actual text of the proposed litigation and its cover letter, there subsequently came down a needed order of Harris County Local Administrative Judge, the Honorable Judge Robert Schaefer, thus granting me the right to appeal from this void, future rendition of judgment, which was orally, not by written memorandum being filed with the clerk of the court on May 3, 2018, announced as indicated above, which of many decisions and accompanying opinions of this court declared is void, and still yet the oral rendition announced from the bench by Judge Phillips, has not been entered of record in the official records of the trial court, which are its minutes. I had a heavy burden to overcome, unlike other inhabitants of the state of Texas, which was to first convince said judge that the appeal was not frivolous but arguably had merit, so, I will have attached the same proposed pleading for you to read that the judge below read and granted approval. Yet these two evil sham-appointed attorneys were appointed to step in and protect the kidnapping by Texas of our son, and now needing you all to protect the deep state. Enclosed is my Pro Se petition for review and inclusive motions for orders that court reporter and counsel be ordered to show legal cause on why they should not be held in contempt of court, and I move that you order that the clerk provide all the records of all the proceedings in the trial court, which is the only way to determine on whether or not an appeal is frivolous, for there is no other way to do it without the record, the history of all the court proceedings, thus following the instructions of a deputy clerk of this court to bring to this court's attention of the professional misconduct by appellate counsel in failing to file in this court her petition for review. The following was and still is the proposed litigation that Judge Robert Schaefer received and granted be filed, preceded by his letters and order of his approval, the local administrative judge who is the only judge that can grant such authorization, whom our real God had in place this judge. Thank you. And with kindest wishes, I am /S/Prophet Ronald Dwayne Whitfield. Below is the proposed litigation which these sham attorneys knew what the issues would be, as did former presidential candidate Hillary Clinton in advance knew what the questions would be. In re. Prophet Ronald Dwayne Whitfield, petitioner/applicant. Seeking to appeal to the 1st/14th Court of Appeals of Texas from a final judgment to be both rendered on May 14, 2018, and by the clerk entered of record in the minutes from the 314th District Court of Harris County, Texas, Trial Court Cause No. 2017-02559J, wherein the state of Texas, for which Texas State Court District Judge and Local Administrative Judge, the Honorable Robert Schaefer, serves, initiated a civil action, not our prophet here whom caused, a civil action to have been commenced against him to terminate his parent-child relationship with his biological son based on uncontested, and known to be false and perjured testimony being presented by an assistant Harris County attorney, and therefore also to additionally present to the District Court of Harris County, Texas, litigation to challenge the Texas legislature's unlawful Acts of 1997, 75th Leg, CH 806, Sector 1 EFF September 1, 1997, as unconstitutional, as creating a denial to equal access to the courts, even though such court must and shall always be and remain open, to all persons injured, which challenge of attack was taught to this prophet to do, and successfully, by our late and former Texas Court of Criminal Appeals Judge, Hon. Marvin O. Teague. Last Prophet Ronald Dwayne Whitfield's original petition/application under the Texas Civil Practice and Remedies Code sections 11.101 and 11.102, A-D, for herein he is now more formally in this or that manner, seeking permission to present to and file in the Harris County District Clerk's Office both a new litigation to which the pre-order is in place in the state of Texas unconstitutionally and presumably applies to him, and a separate proposed appeal, which, of course, is not 1. A civil action per se, not to mention since the same was not commenced, maintained, and or caused to be pending in any state court or in any federal court by him, and 2. The proposed appeal is not being taken from a judgment of a trial court, as would logically constitute a new litigation, and, finally, such a legal term here itself and such a proposed appeal itself being presented to and for the judge to judge its merits, as to whether or not the same should be approved by the judge of this court, has not been legislatively defined, as in terms of the statute itself, unlike other terms that have been, and, therefore, the term appeal itself cannot just merely be presumed by the judge of this court nor of any other court, without statutory analysis, so construed here as it to have been in the intent of the legislature, in enacting this unconstitutional statute, to mean that the word means it also includes a new litigation. As Judge Teague would argue in dissent were it otherwise the case, surely the legislature was aware that at the time its members voted on the bill on the floor, its sponsors and its author knew that there are no plaintiffs and there are no defendants on direct appeal, neither in criminal prosecutions nor in civil actions. Notice to Director and Deputy Director of the U.S. FBI and Department of Justice Special Litigation Section, and U.S. Attorney and Assistant Attorney Adam Goldman. Governor of the State of Texas, Texas Board of Criminal Justice, Executive Director of the Texas Department of Criminal Justice and the Inspector General thereof, and Director of the Texas Department of Pardons and Paroles Division. Official notice of food and water strike at Houston FBI to call worldwide attention to Judge John Phillips' actions as described herein below and not allow the parents to be heard and to contest the false allegations of child abuse and to make complete and timely objections and obtain an adverse ruling to preserve appellate error as the court explained that his trial counsel failed to do to assist him in a criminal trial in 1992, thereby presenting no legal, reversible error for review, and to refused to hold hearings on their plea to jurisdiction pleadings and 100 motions to dismiss and for him to recuse himself and to otherwise afford them in their right of trial by jury, on all questions of fact, even as to the father dispute that he had been served the legal documents that he merely received from not a deputy constable but from Miss Crystal, a deputy clerk, immediately after the final judgment expected to be rendered in this case on May 14, 2018, for the reader will read in the transcript that not only does the father know how to conduct himself as a lawyer and of his God-given right in civil and in criminal cases and that he must put the opposing party to burden of proof and move a judge to admit into evidence any evidence he might introduce, unlike the opposing counsel who allow her case to rest and close without stating, at any time, the state would ask that you admit our exhibits into evidence as these court-appointed counsels will object to nothing we say and offer. And notice that the time not only has come that I now release videos to the public that I complied with the non-written instructions and all of the written instructions of the parole officers to report to mental health authorities, both on my own initiative and per their instructions, which was killing the parole attorney that the parole board appointed because I would not agree to allow her introduce into evidence postmarked letters from the crazy lady and the crazy doctors to prove the parole authorities were retaliating against me and lying on me that I had not been reporting, such that I explained to her that you discover more by allowing people to think you are stupid and thus I not only now present to you such letters that I have now nor have I ever had any mental issues, but also that I was unlawfully arrested as a parole violator the last time as well, for I recorded the last mental health assessment by the crazy doctor who went into the system and stated that I was not scheduled to report for mental health assessment by him until February 13, 2018, I think, and not on February 1st, 2018, which you locked me up for, and at the final hearing before Judge Phillips on last week, the state not only continued to lie and mislead but also caused her witness to lie, and thus deceive that my parole was twice revoked. Not that I was merely arrested as an alleged parole violator. May it please the Honorable Judge Robert Schaefer. May it please our Honorable Attorney General of the State of Texas. As to the state authorities, please. Comes now, not pro se but, in propria persona last Prophet Ronald Dwayne Whitfield and he would respectfully show as follows. Jurisdiction. In this proceeding, see Texas Civil Practice and Remedies Code Section 11.102, d. This court has jurisdiction, or the power, and therefore her presiding judge has the lawful and judicial authority to render an order to authorize our last prophet to present for filing in a civil district court of Harris County, Texas, a new litigation, to which a pre-filer order applies to him, as on the legal theory that Chapter 11 of the Texas Civil Practice and Remedies Code is, in its entirety, unconstitutional and is for all the reasons since March 3, 1993, as stated in the well-written majority opinion filed in the dispute between Texas Association of Business v. Air Control BD, 852 SW2D 440, 1993. However, and notwithstanding and, even still, such order only applies as to one who the Texas legislature terms, but has not legally defined, pro se, we will have nonetheless shown to the presiding judge that may grant permission to a vexatious litigant subject to a pre-filing order under Section 11.101 to file a litigation since it will clearly here appear that TH's proposed litigation has 1. Merit and 2. Has not been filed for the purposes of harassment sic or delay sic. The law applied to the facts within a statement of the case. Pursuant to the Texas Rules of Civil Procedure, we adopt and incorporate by reference all legal authorities cited, as if were set out in full herein. As you know, you will herein be called at times to exercise your context clue skills in discerning the clear breadth of the statute herein under review. Civilly dead. We dive in and first in argument, that the said statute is unconstitutional, generally, and unconstitutionally as specifically applied to our prophet in that he claims that if and since he cannot file a new litigation, pro se, whatever that legally means, to sue the state of Texas, then neither can he, 2, be sued by the same state of Texas for his biological child, Allah. Do not unto others as others may not do unto you. Notwithstanding, and even still, the statute, we conclude from the plain meaning stated in its definitions, see section 11.101(1-5), as well as from the very plain language of the text of the law itself that only in a trial court is a defendant called a person or governmental entity against whom a plaintiff, which we are told, means an individual who commences or maintains a litigation pro se. Our prophet certainly knows that he not only did not commence and or cause be maintain this litigation nor so as pro se, whatever that legally means, but also he certainly knows that had the legislature intended the term litigation to apply to appeals taken from a civil action commenced in a district court of the state of Texas, it would not only have so stated, but also would have included in her definitions that a plaintiff includes an appellant or appellee and a defendant includes as such. Likewise, for if in the trial court, the defendant loses, then the same becomes on appeal the appellant and the plaintiff becomes the appellee. What is an appeal? An appeal is not a new litigation, but it is simply a continuation of the same litigation commenced by the plaintiff against the defendant in the trial court below, on. More specifically, it is a petition to a higher court by the losing party in a lawsuit to overturn a lower court's rulings and judgment. Therefore, an appeal does not constitute new litigation, a new trial. This is true in fact because, in an appeal, there are no new issues to be presented nor any new witnesses to be called to testify. The appellate court will only review the transcript of the trial court and the evidence, not only just introduced, but also judicially admitted. Yet on the record there was none admitted into evidence, just only offered. Class, sing the song called This Issue Has Merit. In the trial court, see Steele. Kobe Citizens for a Better Environment, 118 SCT 1003, 1998, and also see Texas Associations, Supra, not just only in their plea or challenge to jurisdiction pleading and motions to vacate the 2 ex parte orders owing to no notice and an opportunity to be heard, and so forth, and to dismiss and notice to make not a general but to make a special appearance for the mandatory initial hearing, which was not held at all, not even ex parte, and which a deputy district clerk assigned to the courtroom shown above admits that she received from our prophet in person who claims she and filed, but was not responsible for scanning it into the system, stamped as filed on May 10, 2017, 2 days after this litigation, but also they had in person, on May 18, 2017, at their first initial appearance then informed Judge Phillips that not only did they decline their statutory right to court-appointed attorneys, thus well aware of such right and of the 20 days within which to file a written answer and make also therein jury demand should they be served process by one being authorized to so serve them, for they knew a court clerk is not authorized to serve process on the parties, but yet they made very clear that they would exercise their right to employ their own attorneys, but Judge Phillips forced court-appointed attorneys on them over their strongest of protest, and also this prophet repeatedly informed Judge Phillips that our prophet had not come into court as one discussing anything with the judge regarding indigence and the merits because he challenged the court's jurisdiction over his person as being a party, on the ground that while he received a copy of both the citation and the petition, he was not lawfully nor legally served same by anyone authorized by law. We trust we need not cite to the judge of this court the Supreme Courts of the United States and of Texas years ago already ruling on this very point in his favor in other cases. Contrary to the teachings in Steele Co. Supra, which court's opinion, in 1998, made clear that under Article 3 of the United States Constitution, of what Judge Phillips has done in this case, WAS essentially the same position embraced by even several federal judges of courts of appeals, which as did Judge Phillips proceed immediately to the merits question concerning the false allegations of child abuse, despite jurisdictional objections, presumably since the merits question regarding what was a factual jurisdictional issue being put into dispute and thus to be resolved by a jury, for it, not Judge Phillips, so as to resolve on whether or not our last prophet had been truthful, that he had not been served with lawful process and thus no personal jurisdiction attached in the case for Judge Phil. But to make a special appearance for the mandatory initial hearing, which was not held at all, not even ex parte, and which a deputy district clerk assigned to the courtroom shown above admits that she received from our prophet in person, who claims she had filed, but was not responsible for scanning it into the system, stamped as filed on May 10, 2017, 2 days after this litigation, but also they had in person, on May 18, 2017, at their first initial appearance then informed Judge Phillips that not only did they decline their statutory right to court-appointed attorneys, thus well aware of such right and of the 20 days within which to file a written answer and make also therein jury demand should they be served process by one being authorized to so serve them, for they knew a court clerk is not authorized to serve process on the parties, but yet they made very clear that they would exercise their right to employ their own attorneys, but Judge Phillips forced court-appointed attorneys on them over their strongest of protest, and also this prophet repeatedly informed Judge Phillips that our prophet had not come into court as one discussing anything with the judge regarding indigence and the merits because he challenged the court's jurisdiction over his person as being a party, on the ground that while he received a copy of both the citation and the petition, he was not lawfully nor legally served same by anyone authorized by law. We trust we need not cite to the judge of this court the Supreme Courts of the United States and of Texas years ago already ruling on this very point in his favor in other cases. Contrary to the teachings in Steele Co. Supra, which court's opinion, in 1998, made clear, that under Article 3 of the United States Constitution, of what Judge Phillips has done in this case, WAS essentially the same position embraced by even several federal judges of courts of appeals, which as did Judge Phillips proceed immediately to the merits question concerning the false allegations of child abuse, despite jurisdictional objections, presumably since the merits question regarding what was a factual jurisdictional issue being put into dispute and thus to be resolved by a jury, for it, not Judge Phillips, so as to resolve on whether or not our last prophet had been truthful, that he had not been served with lawful process and thus no personal jurisdiction attached in the case for Judge Phillips therefore to proceed where even if, 1. the merits question had been more readily resolved, and, 2. the prevailing party on the merits would be the same as the prevailing party, i.e., the state of Texas, were his jurisdictional challenge denied by Judge Phillips. Citations omitted. The Ninth Circuit has denominated this practice, which it characterizes as assuming jurisdiction for purpose of deciding the merits, the doctrine of hypothetical jurisdiction. Citation omitted. Judge Phillips W.E. declined to endorse such an approach because it carries the state and the federal courts beyond the bounds of authorized judicial action and thus offends fundamental principles of separation of powers. Without jurisdiction, the court cannot proceed to the merits question at all in any cause. Jurisdiction is the power to declare the law upon the facts proven or otherwise just resolved by the jury or the judge, sitting as a trier of facts, and when it was challenged and yet not resolved, it ceased to exist, and therefore the only function remaining to the judge of the court was that of announcing the fact and dismissing the cause. Judge Phillips, there is a constitutional requirement that jurisdiction be established before you proceed to the merits question. You would be really a fool to waive the defect, since the two void orders placed him at a disadvantage, since no initial hearing in fact had been held, and yet orders purporting to have been by you rendered and entered by the clerk, also filed at the very same minute the petition was filed, both so-called proposed orders and the petition, and purportedly signed, by a stamp, by you as a threshold matter which now should explain our prophet's behavior, which matter springs from the nature and limits of judicial power of the United States and is inflexible and without exception, which is the same legal position that our Texas Supreme Court had taken in Texas Association, Supra, 5 years before Steel Co., as well as the fact that Chapter 11.101 would be unconstitutional, which decision came down some 4 years before its enactment. There, the Texas Supreme Court's opinion explains that the separation of powers doctrine is not the only constitutional basis for standing which the Texas legislature seeks to confer by law on the Texas Department of Family and Protective Services, and the sufficiency of the allegations of its pleadings allege child abuse claims to confer jurisdiction. Going to the subject matter. Under federal law, standing is also an aspect of Article 3 limitation of the judicial power to cases and controversies. Citation omitted. To comport with Article 3, a federal court may hear a case only when the litigant has been either threatened with or has actually sustained an injury. Citation omitted. As such, the Department, 2, must both allege and prove by clear and convincing evidence each element to its claims under its allegations of child abuse, but the boilerplate allegations not only do not confer any standing upon the department and thus subject matter jurisdiction in the trial court, standing being a component of jurisdiction, but also pleading boilerplate allegations to deprive one described by the 14th Amendment to the original Constitution of the United States. The State of Texas is not authorized to make such a law, and likewise in still doing so violates substantive, not just procedural, due process of the law of the land and deprive, unlawfully, one of the equal protection of the laws. Under the Texas Constitution, standing is implicit in the open courts provision, which contemplates access to the courts only for those litigants suffering an injury. The department must factually allege, not by boilerplate but by clear and convincing evidence, ultimately prove, not to Judge Phillips, but to a jury upon demand, that both the mother and the father either threatened to injure or that they did injure their son. Only if that were done may the case progress on to rehabilitation of the parents to reunify the family through ordered programs and orders that the parents actually receives, legally issued to them from a clerk, if they are to be binding, Judge Phillips. Yet no such verbal nor written orders rendered or filed with the clerk of the court, which Judge Phillips has assumed to rely upon, were so issued to the parents, which is a legal term of art when used in the law. The record does not show that the clerk of the court issued any orders to anyone to do anything to get their child back. Reverting to the provisions of the statute in question, which violates the open courts provision of the Texas Constitution by unreasonably restricting by its terms a person's access to the courts, as here, such that anyone in the state of Texas claiming standing may bring a litigation against him, thus suing him for his very own child and anything else. Be it therefore remembered that citizens must have access to those courts unimpeded by financial barriers, and definitely, meaningful legal remedies must be afforded to our citizens, so that the legislature may not abrogate the right to assert a well-established common law cause of action unless the reason for its actions outweighs the litigant's constitutional right of redress. The right to trial by jury has been repeatedly demanded but by Judge Phillips ignored and denied without comment. Therefore, Texas constitutional guarantee to trial by jury in a parent-child relationship case, both in its own right under the Texas Constitution, and under the open courts provision since the court was closed to the jury trial right. Specifically, the open courts provision provides, all courts shall be open, and every person, and our prophet is a person, is not he, for an injury done I'm ordering his parent, child relationship rights per se be terminated, and moreover based upon lies provable, in H's lands, goods, person, or reputation labeled in society as an abuser and of his very own child, and at that, not even one of someone else's child, not meaning that that would be better, shall have a remedy by due course of law. Text. Const art. I Section 13, emphasis added, dot. As previously stated, this opinion is fully set out herein. But we go one step further. Texas Family Code Section 102.003(6) generally provides, and without more, that an original suit may be filed at any time by 6. The Department of Family and Protective Services, such that Section 102.0035(e). Judge Phillips is not authorized by any law of Texas to have twice ordered bailiffs to remove our prophet from the courtroom for the few objections that he reluctantly made. Yet that he did. In this case, it was uncontested, which is a clear denial of procedural and substantive due process and the equal protection of the law. There was not only not one objection made by the attorneys that Judge Phillips appointed to represent the parents, over their objections, nothing by said attorneys offered into and thus nothing admitted into evidence, nor their insistence on trial by jury being allowed, nor a timely answer and jury demand therefore being filed by the attorney purporting to representing the mother, as well as no answer and jury demand filed at all by either one of the two court-appointed attorneys. Judge Phillips forced upon the father, but also there is no place in the record did these said attorneys cause the parents to also tell their side of the same story that Judge Phillips allowed be told by the state of Texas, the master for which he serves. Unless a dispute or controversy exists, objections allowed by the parents, unless the allegations are contested, as in to be opposed, the state has met her burden in this case that the only evidence being presented, which was hers alone, showed clearly and convincingly that the boilerplate allegations were true and correct, and not misleading, but for the state action in this litigation. Now, not only, and also is Judge Phillips never authorized to proceed to the merits as indicated above, but also he is never authorized to so proceed to the merits with, among all the other timely, pending decisive motions he has ignored. And he is also not authorized to proceed to the merits questions as long as there is a timely motion for him to recuse himself. A copy of this petition as required by the statute shall or will have been served the day of filing upon opposing counsel. The trial transcript shows that Myron Evans, a CPS caseworker and an investigator, among other witnesses for the state, committed perjury and otherwise made many false, material statements. One such perjured statement is that he was the investigator in this case, another of which the mother of the parent, wife, informed him that she is a drug user.